Thank you. Thank you, Shyam, for that wonderful introduction. Um, Mr. Shamdevan, Mr. Srinivas, Mr. Acharji, the Honorable Justice Mukta Gupta, Mr. Kumar Pandey, and friends. When I was put onto this panel and I saw the list which was sent to me on email, I was like completely intimidated because these are these very eminent people on criminal law. And my experience of criminal law is, as Napoleon said, some are born great, some others become great, still others have greatness thrust upon them. So mine is the last case, is when I became Additional Solicitor General. I came from a background of largely original side practice in Kolkata. And when I became Additional Solicitor General, I was told that there are two things which you have to do, two subjects which you have to handle, which I knew very little about. One is tax and the other is criminal law. So that's my experience. It's been learning on the job. So, if I make any mistakes, and I've appeared a number of times before Honorable Justice Gupta, and she has, on various occasions corrected me as to my perspectives on the law. So I'm very, very careful, and I may be wrong. So, but these are my perspectives on the new act. So I apologize in anticipation. And coming to the question at hand, I think there is no doubt that the criminal laws needed a relook. Let's not be under any debate or any, some people have, and I've heard this being said, that it's old, it's worked. Some people are even saying that if the British applied it all over the Commonwealth, starting from Africa to Malaysia, and everybody still applies it, what's wrong with it? I think especially the Criminal Procedure Code, IPC required updates, and that's happened as well, because it has happened across the law everywhere, all across wherever the criminal law jurisdiction exists because of time. But the Criminal Procedure Code specially required huge updating. The reason why this huge updating was required, because procedure requires updating from time to time. And it's not the first time where Criminal Procedure Code was being updated. In 1973, there was this sort of, once more, there was this updating. The IPC is very old, but in 1973, I think there was a updating attempt to the Criminal Procedure Code. Not very much changes, but substantial changes as well. Now, why do we need these changes? Number one, the world has changed. Technology has changed tremendously. When the Criminal Procedure Code, the original Criminal Procedure Code was framed, it was the world of the telegraph. It was 1857. When you recall this, that 1857, the telegraph was used to indicate to the British cantonment in Delhi from Meerut that the soldiers had risen against the British. So it was, that technology is that old. And today we have internet. Today we have audiovisual technology. Today we have technology which is almost completely different. We live in a completely different world. The society that we live in has changed completely. And not only in India, but all across the world. Now, the other question, and which I will address in detail, is all of us know that we worked this procedure. We worked this procedure even from 1973. There are literally 50 years old. So that last major changes was like 50 years old. So to make substantial changes, the law has changed, the procedures have changed, the requirements have changed, the society has changed, the law has been worked on. And this is going to be my last suggestion, saying that whatever the act is, it will happen, but we'll have to work on the law. There are concerns which we have come across while addressing the procedure code. I think one of the major concerns which has been often discussed is that sometimes the process becomes the punishment. And it's also been discussed largely that we need to recenter the law to have human rights perspectives, especially in criminal procedure. There have been, we've throughout, the last 50 years, we've had various different suggestions, including, I think, the Malimat Committee, which sort of discussed as to what changes of procedure could be done. And the last one was, I think, Mr. Ranveer Singh's committee, who was a teacher of mine, who suggested certain changes in the law. So, it's not that it's a new thing. It's not that it's something which the government thought out of the hat. It is something which was a long time coming, and I think it was discussed in great detail, and changes have been incorporated. Some would say, completely a re-look at the law was required, and that is what has happened. One issue which I was flagging is, the biggest thing, and this I'll stress on as to when I discuss the provisions of the new code, is that technology had to be incorporated into the process. The old process did not have space for technology. Because the technology has completely changed. You can now in real time, for example, record evidence. You can have, and we saw during the pandemic, we could have courts and being conducted through audiovisual means. We've had, and I've seen some of these trials in Britain happening through audiovisual means. I've seen people being brought in, cross-examinations being done. So, we had to, any new procedure which sort of tries to govern New India, which, had to incorporate these things. So it's extremely important that that be incorporated. So that is one of the things. The second is, there was a requirement, and I think it's a genuine requirement, that the code needed to be recentered. And recentered on a human rights perspective, to the extent that the process, as I said, as I discussed, does not become the punishment. So there had to be some sort of a timelines which had to be fixed on which certain things could be done. I think these are the two major takeaways, according to me, broadly, which the Act changes. One is it incorporates technology into the criminal judicial process. And two, it sort of fixes a timeline on which things can be done. But the question is, of course, whether those timelines are going to be strictly adhered to or not. That depends upon the courts. And as I always say that, the Act has to be worked out. It's still a work in progress. An Act is an Act, as we all know as lawyers, as litigation lawyers. It needs and time to work it out. And a lot of things will happen. We will realize sometimes it works, sometimes it doesn't work. But I think that the Act is a great, great idea. You also have to, in this, you also have to realize, and something which is not discussed and possibly not discussed in places similarly situated, is that both the Criminal Procedure Code and the IPC is in some ways a product of colonial approach to police, colonial approach to the state. So it required from a colonial approach to a nationalist, for the want of a better word, national. I know in some circles nationalism flashes red lights, but I think that it's important that we sort of take it out, and the penal code has reflected some of these changes. So that it required a reframing of the Act so that it makes it more receptive to the individual concerned, which takes care of both the accused as well as the person who is subject to the trial. Now, I will just, sort of towards the second part, I will flag some of the broad provisions which I think address these issues. A lot of wide changes have been made on different aspects of the law and process, which have, according to me, been changed and updated. the first aspect, as I marked, was bringing in technology. I think if you see section 2A and I, which introduces audiovisual and electronic communication, saying that you can do that, recognizes that. Section 37 clearly indicates that the name and address of the arrested be prominently displayed on digital portals of the police station as well as the district headquarters. Now, all of us know who've been involved in, address it, and sometimes I'm on the other side, so that if a person is arrested, you know that the person arrested. So that goes right out immediately. So I think that's a great step. I think a lot of questions, and we face a lot of times, I think, those who come to the court saying that whether they don't know whether the person has been arrested or not. So once a person is arrested, his name goes up, publicly. 2, it recognizes the electronic mode of communication for identification of the accused, for serving of summons, for recording of statements of the accused or witnesses. Interestingly, it says that whenever you are on search and seizure, whenever you sort of compile the search and seizure, you get it audiovisually recorded. And it says that for offenses punishable more than 7 years, forensic evidence and videography of evidence collection is mandatory. These are things which I think in some ways we all talk about substantive law and substantive justice and substantive laws being protecting against human rights violations. But according to me, and I think most criminal lawyers will agree, it's the process which protects the rights of the accused. So it's very important to have a process which is fair and a process which is transparent. The second aspect is about the timelines. If that's a hurry, I'll just go through it. I think there are a large number of timelines have been fixed on large number of issues, including police to inform victim complainant about the progress of investigation. There is timelines finished for conduct of investigation during trial. There are timelines to file discharge applications. You have timelines about judgments to be given. Summary trials have been allowed in all cases where imprisonment is less than 3 years. No more than 2 adjournments, which is, I think, would be applicable to us. Judgment to be uploaded on the portal within 7 days. Again, something which, as lawyers, which we feel is very important. And timelines for, have been also for mercy petitions, because we know that there are a lot of games which are played. So that has been fixed. Of course, bail has now been defined, and anticipatory bail. Anticipatory bail, as all of us know, had very specific grounds. That has been removed. Overall, I think it was extremely important to make these changes, and it's very good that these changes have come. I laud the act. As I say, the wordings of the act, the name of the act itself, I think is a reflection of us trying to come out of our colonial mentality and hangover. It's in an Indian language, and it's in the official language of the country, and so therefore, to that extent, it's a change. I think this is the first time in a Union Act has an Indian name. I may stand corrected, but that's my knowledge of the subject. Last, and this is what I'm saying again and again and over again, this act has to be worked out, and there would be no act, no legislation is perfect, and it will have to be worked out by the courts. And whether the courts, to what extent the edges are evened out depends upon the courts. And the balance of the accused and the victim which will be struck will depend on the jurisprudence which comes out of that. Acts are welcome, but it requires working out. Let's see once it comes into effect. Thank you very much.